Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, we are still seemingly at a standstill. Well, the county of Suffolk up in Long Island, New York is anyway, when it comes to settling the lawsuit that Justyna, Zubko-Valva has against Suffolk County due to ignoring the years of warnings and abuse that led to her son Tommy's death. And this is horrible. And for those that are not familiar with the case, it is horrific. I've covered it extensively on the channel. Little Tommy, who you can see on the screen, he was very, very abused by his father and step monster in their Center Moriches home. And in January of 2020, he died, allegedly of hypothermia. And a jury found both his father, Michael Valva, and his step monster, Angela Pollina, guilty of murder. Now they are both serving life in prison, life behind bars, but there is a lot more to this case. Besides the criminal part, it seems to be done, but there's also more going on, according to Mama Justyna, and I believe everything that she says. She has no reason to lie, and she took her other two boys. Tommy was one of three children. She took the other two boys and she fled the country because she had enough, and I don't blame her at all. They have been trying to settle this lawsuit for a while now. I spoke about it about 3 months ago, and it's the civil lawsuit filed by her. And now the judge is ordering, as of, I believe it's April 24th, if I have the date correctly, Magistrate Judge Lindsay is ordering that mediation be done in this case because it may be productive to resolve through a settlement, because they've been having a lot of back and forth issues. Now, an attorney for Justyna told the judge that she would be willing to settle for $10 million, but apparently this whole mediation thing is a problem for Suffolk County because she doesn't want to mediate, and she does not want to get her surviving two boys involved in depositions, which I totally, completely understand. They have been through hell and back, and it's crazy. Newsday have covered this extensively. I will say that Justyna is not a happy camper with the coverage that Newsday gave this on April 30th. So let me read to you, let me pull it up, and I want to read the letter that she posted. She posted it on Facebook. She is very public about these sorts of things, and I normally have high respect for Newsday, and it is really sad that they did not wait and take, listen to her side, before they did this article. Hopefully they will, put out something in the next few days, discussing Justyna's side of this entire lawsuit, because I think that they owe that to her, to cover both sides of the situation. All right. This is going to be a bit blurry because I tried to blow it up as much as possible. So it's maybe really hard for y'all to read. So I do apologize for that. But just so I can read it to you guys, I had to, blow it up, enlarge it to this degree. So, obviously this is a letter from Justyna Zubko-Valva, to the judge, and this has to do, and this is actually to Judge Edward Corman. So I believe there's multiple judges involved, but the judge that put the order for the mediation is not this judge. So yeah, I'm not really sure all the parties that are involved besides her, obviously, and Suffolk County. So she writes, Dear Honorable Corman, I, Justyna Zubko-Valva, am the plaintiff in the above referenced civil rights action. I'm writing this letter to the court respectfully requesting ADA accommodations involving court's permission to participate in the mediation process by video conference due to extraordinary circumstances pertaining to my children's medical and educational needs. As a primary and only caregiver of my 2 surviving children, older son Anthony has been diagnosed with autism since childhood. I am obligated to provide 24/7 care, assistance, and help for my 2 surviving sons, who are the victims of past long-term horrific physical, mental, and sexual abuse, as well as unimaginable brutal trafficking by their father, Michael Valva, and his fiancée, Angela Pollina, and other high-ranking officials who paid skyrocketing sums of money to Valva and Pollina for my children's abuse. Let me pause for just a second here. I mentioned it on the channel. I haven't done an extensive deep dive, but the allegations are, and from Justyna, from the 2 surviving sons, the 2 surviving boys, that they were sexually abused, and it was horrific. So not only were they put through hell in that home, and their brother Tommy was treated also like garbage, and he was murdered. They went through horrific things that are unimaginable. So I understand where she's coming from 1000%, because she does not want to put these boys through any further emotional, mental, all that. You know, they've been through enough. At this point, she's probably been trying to give them as much of a normal life as possible, and that's got to be hard because they have a big hole in their family. You know, little Tommy is not there. As a result, my 8-year-old son Tommy was brutally murdered by Valva and Pollina on January 17th, 2020. Both Michael Valva and Angela Pollina were found guilty by separate jury trials and sentenced to 25 years to life in prison for the crimes they had committed against my children. The impact of this horrific, unimaginable, and heinous abuse has been forever imprinted in my children's hearts, and extremely painful memories of the past affect their everyday lives till this day. As a result, my children are forced to face many difficult challenges, struggles, and hardships that impact their lives day after day. They continue receiving medically necessary therapy, and for the past couple years, under my supervision, my children have been participating in remote learning education to ensure their medical and educational needs are appropriately addressed. Moreover, even other judges that presided over the court cases involving my children expressed publicly and on the record that they have never seen such horrific abuse for the duration of their entire careers as judges. The countless pieces of paper and electronic evidence existing in this case speak for themselves. My priority as a loving and caring mother is to ensure that my children's healing process continues to successfully progress forward, so they can always feel safe, protected, loved, and assured that my care, assistance, help is always available to them. Again, I think she is right on the mark here. My request for ADA accommodations is directly related to recently issued court order dated April 24th, 2025 by Judge Lindsay. It's hard to understand why the context of the order contains many baseless attacks towards me without giving me a chance and lawful right to express my own position in the matters discussed in the order before the issuance of such order. Judge Lindsay issued her order based on the letter submitted to the court by my attorney, Thomas Valva, on April 14th, 2025. Unfortunately, the letter was never served upon me by my attorney, despite the fact that Judge Lindsay's part rules require copies of any letter submission be simultaneously delivered to all counsel and with service on all parties. I was not aware of the existence of such letter until I read Judge Lindsay's order dated April 24th. As a result, I was unlawfully deprived from writing my own letter to the court in response to my attorney's letter, and I was not able to inform the court about my position in the matters discussed. Despite the fact that I was unfairly deprived from due process of law, justice, fair and impartial treatment, as well as any information related to the emergency telephone conference that took place between Judge Lindsay and all parties involved on April 23, 2025, the order dated April 24, 2025 was still issued by Judge Lindsay with tremendously harmful terms and consequences for me and my children. Specifically, the order states that, quote, a telephone conference was held on April 23, 2025, at which time the parties were advised of the court's intention of referring the matter to mediation and input from the parties was solicited. All agreed that mediation at this time may be productive, unquote. Again, this decision was made without my knowledge and approval, despite the fact that I am also a party appearing in this case. My attorney failed to inform the court that my position in this matter should be taken into consideration before the decision regarding a mediation can be made. As this court is aware, the parties involved already went through a mediation in this case, except defendant Donna McCabe, Esquire, who refused to participate, in which both mediator and my former attorney, Mr. Norrisberg, Esquire, attacked me, threatened me, screamed at me, called me names, and laughed at me for the purpose of forcing me to agree to their very harmful terms of mediation that benefited defendants. This mediation, very costly in attorney fees and mediator fees, serves no purpose at this time, as we are very close in reaching the settlement with county defendants. For the past several months, I kept requesting times and times again from my attorney, Mr. Bosworth, Esquire, to write a letter to the court informing the court and county defendants of my counter offer of $10 million in response to county's initial offer of $3 million to no avail. Yeah, $3 million, I gotta tell you, that's pretty much a joke. And this is not a funny situation, obviously. Only recently this information was allegedly provided to the court per my attorney's claim in his email. The settlement in this court matter could have been reached many years ago, as I expressed my will to settle this matter since I hired my former attorneys as well as my current attorney. Therefore, taking those circumstances into consideration, a settlement conference with county defendants should have been scheduled instead of mediation, especially that proposed settlement accounts are in close range to each other, and Judge Lindsay indicated during the conference on January 8th, 2025, that in such circumstances, the settlement conference will be scheduled. Moreover, in order to ensure the settlement can be reached in this court matter, with original amount that was initially requested by my former attorney of $200 million. The insurance coverage for county defendants allegedly equals to $66 million. Unfortunately, despite my multiple requests, my current attorney refused to verify the insurance coverages for each of the defendants till this day. The remaining defendants, East Moriches Elementary School and Suffolk County Legal Aid, proposed very low settlement offers. School defendants proposed $90,000 and Legal Aid proposed also $90,000, despite the fact that their insurance coverage allegedly equals to $27 million and $2 million respectively. Defendant Donna McCabe did not provide her initial offer at all for the settlement purposes. Therefore, the mediation with those remaining defendants would not be productive at all. Yeah, so we were getting close, I thought, as well a few months ago. So I agree with her. It sounded like to me that they were getting close to something, and I've been waiting for an update, and sadly this is the update that we're getting. In regards to further accusations presented against me in Judge Lindsay's order dated 4/24, it is not true that I have been uncooperative in discovery process. I have many evidence, text messages and emails requesting from my attorney, Mr. Bosworth, to send out subpoenas to Suffolk County DA's office and potential witnesses for the production of their official paper and electronic records that are the foundations of our discovery process as well as any mediation process. My requests were countless times ignored by my attorney, despite the fact that without those crucial records, the trial in this case is destined to fail. Similarly, the depositions or mediation in this matter are ineffective without first obtaining the official records through court-ordered subpoenas, as evidentiary findings are the key to win the trial, succeed at depositions or mediation. So far, everything that was done by my former and current attorneys to keep the court's involvement in this case as little as possible. Therefore, the progress in this case has been stalled due to actions and decisions made by my attorney who, despite of being granted the period of 9 months since his hiring, refused to complete the discovery process based on obtaining all necessary official records by court-ordered subpoenas. Mr. Bosworth, against my will, knowledge, and approval, only obtained the records from my former attorneys, who tremendously harmed my case to benefit defendants. The only logical cost-free solution to move forward in this case court matter would be settlement conference with county defendants, where initial offer and counteroffer have been already presented. Contrary, a mediation is very costly and currently ineffective as the discovery process has not been finished yet. Again, she is very organized, and it sounds like her current attorney she's not happy with Bosworth at all. Judge Lindsay, in her order dated April 24th, allowed a personal representative for each party with the authority to approve any settlements be present at the mediation. All defendants except me were permitted to use their personal representative to attend mediation. This is very unfair, especially that I have been sick and tremendously affected by past horrific abused children who need my care, help, and assistance 24/7. Despite the fact that my children's tragedy was caused by defendants' crimes, they are being provided with pleasant accommodations. Contrary to me and my children, the true victims in this court matter. Judge Lindsay's order dated April 24th inaccurately claims that I failed to appear at a prior mediation. I appeared remotely via video conference due to difficult circumstances regarding my children's special care. Defendant Donna McCabe, on the other hand, failed to appear at all together with her attorney without prior notice. She was not mentioned in the aforementioned order. Judge Lindsay, in her order, threatened me to impose sanctions in the event I failed to appear in person for this mediation. Furthermore, I was threatened to pay attorney fees of each defendant who appears for the mediation, or my case will result in a recommendation to the district judge that the action be dismissed. It is very unfair that such harmful order containing so many threats was issued only against me without providing me an opportunity to defend myself and my state and state my position regarding matters discussed. Yeah, I mean, can you imagine? So the judge, this judge is threatening. She doesn't show up for mediation, she's going to have to pay them. And like, she hasn't been through enough as well as her boys. Yeah. Moreover, I am an indigent person who was granted poor person relief in all my court cases in Suffolk County Family Court and Nassau County Supreme Court due to my financial hardships, lack of child support, and steady income. How am I supposed to pay for the aforementioned attorney's fees or sanctions if I am barely able to pay for my and my children's life expenses, including food, clothing, fuel, bills, medicine, hygiene, and cleaning products, etc.? I cannot deprive my children from their basic life necessities, such as food and shelter, in order to pay court-ordered sanctions and penalties unfairly imposed only on me and my children, who are the victims of this horrific tragedy that resulted in brutal murder of my 8-year-old son, Tommy. Yeah, this judge should also, the judge who granted Michael the custody of his boys, oh, that's a whole other thing. I mean, it kind of goes back to the whole thing with Adam Montgomery too. There is so many judges out there, sadly, that deal with these CPS cases, and it sounds to me like this particular civil court is really giving Justyna a hard time. And like I said, she doesn't deserve that. They have been through quite enough. The court should provide necessary aid for the victims, not punish victims to help their abusers, especially that they have enough money to pay their own attorney's fees since the commencement of this court matter. This is not understandable and truly questions Judge Lindsay's fairness and impartiality in this court matter towards me and my children. Moreover, it's not the first time Judge Lindsay issued such harming me and my family order. My former attorneys, who tremendously harmed my case, were permitted to file a lien for their attorney's fees, despite the fact that they are never officially requested such relief by motion practice. At the same time, I was deprived from filing my opposition papers in this matter. Moreover, Judge Lindsay was informed in my prior court papers about the official retainer agreement signed between me and my former attorneys, in which they agreed to not ask for any attorney's fees if our relationship attorney-client breaks apart. Moreover, I was unfairly accused by Judge Lindsay to unnecessarily prolong this court matter during this time when I looked tirelessly to find a new attorney representing me and my children in this court matter. After my former attorneys suddenly abandoned my case because I discovered they had been harming my case instead of helping me and my children receive justice in this court matter. Contrary, after I hired a new attorney, the case was rescheduled for a long period of 9 months. And in that time, my current attorneys did not even serve court-ordered subpoenas upon Suffolk County DA, defendants, as well as potential witnesses for the production of their official paper and electronic records. Therefore, I kindly ask that this honorable court for the ADA accommodations permitting me to appear virtually at the mediation due to my obligation of providing full-time care, help, and assistance to my 2 surviving children. Older son has autism, who were subjected to years of horrific physical, mental, sexual abuse, and trafficking, close to death, starvation, brutal beatings, and unimaginable tortures. Video court appearances have been fully accepted and widely used by all courts around the country, including my other court cases. Also, even federal rules of civil procedure 30B, 4, and 43 supports of depositions being taken by telephone or other remote means, as well as judges may allow witnesses to testify by phone or video call for good cause in compelling circumstances. The tragic situation involving my children highly qualifies for these aforementioned compelling and extraordinary circumstances that should make the mediation process for me as my children's mother possible to attend by this honorable court's permission to appear virtually. Moreover, recently adopted by the court system, new rule to erase judicial accommodations for people with disabilities, dated March 15, 2024, please see attachment, creates an important new procedure that allows individuals with visible or invisible disabilities to make a request for ADA accommodations and authorizes judges presiding over a pending matter to entertain such requests on an ex parte basis without unnecessary compromising privacy of individuals applying for it. According to Chief Judge Wilson, this new rule was created to ensure that the unified court system remains steadfast in its commitment to the pursuit of fair, equitable access to our courts and justice system for all New Yorkers, regardless of need or ability. The court system adoption of the new Part 52 marks another step forward in our ongoing efforts to close the justice gap, serving to facilitate the reduction of physical, communication, and other barriers to justice confronting people with disabilities. Therefore, I kindly ask that this honorable court issues a positive decision regarding my request for ADA accommodations and considering hardship circumstances regarding my children's care described above, permits my equitable access to the court ordered mediation by video conference. I thank this honorable court for its consideration of my request. Respectfully submitted, Justyna Zubko-Valva. And she has the attachment here about that. Now, the reason that Justyna posted this publicly, you can see a couple days ago, is because of the Newsday article. It doesn't seem like that they did their due diligence in checking with Justyna on this matter. So, yeah, that's disappointing. And she's having issues that the letter's not appearing on the court docket on Pacer. So, again, she's saying that she's pretty much upset with Newsday, the Newsday reporter that did the article, because, they didn't check with her. And I have to say, she has a point. They should have followed up with her. I mean, I'm sure she would have responded to Newsday had they reached out to her. Yeah, so like I said, that this is not over. There's still ongoing fights about the civil lawsuit. And it is frustrating that this is still ongoing for her. And no, in any of these circumstances, when it comes to these abused, murder victims such as little Tommy, you're never going to bring him back. And his two brothers are going to forever be scarred and have to deal with everything that they have been through because of their father, what he put them through. But if the lawsuit can make them have to, take a hurt to themselves and publicly show that this was done, and most of all, help this family in some way, because, like she said, they're not a well-off family. She's, obviously they're in a good place together. They're all together, but day by day, I mean, they're struggling. The struggle was clearly there when she was trying to get custody of her boys. Michael had the money because of Angela, and he had the pull because he was a New York police officer. And Justyna, when you don't have any kind of pull or money, it seems like it's a losing battle, and it shouldn't be like that. So I just feel like when can this family truly heal? When is Suffolk County? When are they going to let her have a win? I mean, yeah, we have the biggest win that Michael Valva and Angela Pollina are behind bars. I mean, granted, that is the biggest win, but this lawsuit, and there has been proof that CPS and they all screwed up. Remember, Tommy told Child Protective Services what was going on. He told them. They didn't do a damn thing. So I think that she deserves the $10 million she's asking for. And remember, she wanted $200. At this point, she just wants it settled. She's not going to take $2 million. I mean, I hate to say it's measly, but compared to what she's looking for, and we're talking about the life of Tommy and the life of her other two sons, it is measly. I mean, what is the monetary value of someone's life? There is none, right? I mean, there's really no value. So monetarily, it's priceless. But I hope that they listen to her, and I do have respect for Newsday. I do. And I hope that they can do better, on this one, and maybe they'll do they'll do something on this in the coming days. I really hope that they do, because like I said, they have been they have been really good up till now. They've been one of the better covering Tommy's case in this entire situation. So I don't know. I haven't looked, but I'm not sure what reporter did this particular article, but it does sound like they didn't do all their homework, like she said. All right, guys, I hope you have a great rest of the day, and most of all, stay safe.